Plea bargains. Why you can't undo this decision.
Almost all criminal cases end with plea bargains, not dramatic courtroom trials. But what many defendants don't realize is just how much they're giving up when they agree to a plea deal, and how that decision can impact the rest of their lives. Before accepting any agreement, it's essential to fully understand what a plea bargain is, how it works, and the serious implications involved. A plea bargain is a negotiated agreement between a defendant and the prosecutor. In exchange for pleading guilty or no contest to a charge, the defendant typically receives a benefit. This could be a reduced charge, fewer counts, or a lighter sentence. There are three main types of plea deals: charge bargaining, which reduces the severity of the offense; count bargaining, which reduces the number of charges; and sentence bargaining, which offers a more lenient penalty in exchange for a guilty plea. In each of these scenarios, the defendant waives their right to trial and accepts some form of penalty. Prosecutors offer plea deals not out of generosity, but because these agreements help the system function. Plea bargains guarantee convictions, save the state time and money, and reduce the burden on overcrowded court calendars. Trials are expensive, unpredictable, and time-consuming, even for strong cases. So resolving cases through plea deals helps prosecutors manage their caseloads efficiently. In some situations, they also serve justice by allowing for timely resolutions that still hold defendants accountable. That said, plea bargains can offer real advantages to defendants, particularly when the evidence is strong or the risks of going to trial are significant. A plea deal might result in a shorter jail sentence, reduced fines, or the possibility of probation instead of incarceration. It can also offer the peace of mind that comes from knowing exactly what your outcome will be. In some cases, negotiating to plead to alternative charges may help you avoid serious collateral consequences, such as loss of professional licensing or immigration complications. And for many people, resolving a case quickly allows them to move forward with their lives without the stress and uncertainty of trial. But accepting a plea deal is not without serious risks. When you take a plea, you're giving up important constitutional rights: the right to a jury trial, the right to confront your accusers, and the right to demand that the state prove its case beyond a reasonable doubt. You're also agreeing to a criminal conviction, which can remain on your record permanently. Many people, especially those unfamiliar with the justice system, feel pressured to accept plea deals even when they're innocent, simply out of fear of harsher punishment if they go to trial and lose. In California, the plea bargaining process typically begins with an offer from the prosecutor, often a standard offer based on the type of case. From there, your defense attorney plays a crucial role in negotiating based on the strength or weakness of the evidence, your criminal history, and any mitigating circumstances. Ultimately, the judge must approve the agreement. While judges usually go along with plea agreements, they aren't required to honor all terms, particularly with respect to sentencing. For felony charges, negotiations often take place after the preliminary hearing. For misdemeanors, they can begin as early as arraignment. The decision to accept or reject a plea deal is highly personal and should never be made lightly. It depends on factors like the strength of the evidence, the potential sentence if convicted at trial, the existence of viable defenses, and your personal priorities and risk tolerance. An experienced criminal defense attorney is essential here, not just to pass along offers, but to truly evaluate them, identify weaknesses in the prosecution's case, and negotiate from a position of strength. A strong defense attorney should fully investigate your case before even beginning plea discussions. They must explain not only the immediate consequences of a plea, like jail time or fines, but also the long-term impacts, including probation conditions, restitution, and possible effects on employment, housing, or immigration status. They should never pressure you into accepting a bad deal simply for convenience. Instead, they should be ready and willing to take your case to trial if the plea isn't in your best interest, using the threat of trial as leverage to obtain a better offer. Ultimately, the most important decision you may make in your criminal case might come before trial ever begins. A plea deal can be the right choice, but only if it's based on a thorough understanding of the facts, the evidence, the law, and your personal circumstances. It should be a strategic move, not a desperate one. Don't make this decision alone or uninformed. Having a knowledgeable advocate in your corner ensures you're making the best possible choice for your future. Most people don't realize just how much is on the line when they're offered a plea deal. And once you accept it, it's not so simple to hit undo. You must point to clear factors and good cause for a withdrawal of plea. Make sure you have a skilled legal team in place to help you make the right decision at the outset. If this video helped break things down for you, hit that like button, subscribe to the channel, and share it with someone who might need this info. We post videos like this to give you real insight into the criminal justice system. No fluff, no fear tactics, just facts and strategy. So if you want to stay ahead of the curve and actually understand your rights, you're in the right place. Got questions about your situation? Drop them in the comments or check out the link in the description to schedule a confidential consultation with our team. Thanks for watching!
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.